I'd like to call to order this special meeting of the Anchorage Assembly and begin with a roll call. Madam Clerk.
Mr. Birch? Mr. Birch is joining us on the phone. Mr. Trainee?
Here.
Mr. Honeman?
Here.
Ms. Gray Jackson is traveling. She's excused. Ms. Osiander?
Here.
Mr. Hall?
Here.
Mr. Starr?
Here.
Mr. Trombley?
Here.
Ms. Johnston? Here. Mr. Flynn?
Present.
And Ms. Drummond will be joining us shortly.
All right. So we have a quorum at this point, and I would like then to ask Mr. Hall to lead us in the pledge, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The first item on our agenda here is basically an informal discussion of the draft resolution. Is there, Mr. Starr, would you like to start us off?
I would like to motion for consideration by the body for approval of 2011-248.
Second. Oh, go right into that. All right.
Yeah, I don't see any reason why the word draft was since changed, of course, since we have a hard document in front of us.
Okay, that motion is before us. Is there discussion?
If you don't mind me speaking to that, I think there's several things. One of the things I appreciate now is the opportunity to have the special meeting. The public's business is best done out in the public, and I think, we could have done it through work session perhaps, but I also think that if we can move to action in a direction such as approval of this document, I think it also shows appropriate leadership. What I also feel confident in is our ability to call it by majority of members. There's also that initial observation that you may have a serial meeting, and I want to put that out on the table right out of the gate. Basically, I just felt appropriate to call some of my other assembly members and wanted to take some leadership role in encouraging this meeting. So how it all gelled, even though unusual and termed, was not to take away the leadership role from our chair. That wasn't by mention, but it also was to secure in the meeting tone that other folks on this body had an interest to sort of pick up the topic. What I see that we got in the injunction, and the reason I moved fairly quickly, was I think that there's a window here of an opportunity, and I think that the judge's injunctive statement, in particular statement number 19, which speaks to the three options available to us, gives us that continuing opportunity to negotiate. And for me, the opportunity that this assembly has to sort of urge and enter into those negotiations is a rare window, meaning that both parties are not physically at the table hashing things out. So there's sort of a temporary reprieve, but I also think that there's a recognized opportunity here. My resolution, I think, wants to do several things, and it's more on a global and a practical level that I'd like to speak to that as it is. And attached to the packet, so that the other opportunity here was so that we're all talking about the right thing here. And 2010-86 should be the last page on the document. And it's not a civics lesson, but there is some new people on the body. And the Assembly has a significant role when it comes to labor negotiations and collective bargaining. Primarily, we provide the guidelines, and I think that's not often known. It's sometimes learned by the body. We have to do that well in advance of any negotiations. We watch when contracts are going to come due. We watch all the economic factors, indicators of the city, and then we process a statement such as Ms. Johnson and the others authored back then. I was here and approved that guiding document that the administration takes by charter and goes off and negotiates labor contracts. I think that the first thing I want to do in more of a global speak is to suggest and provide sort of a general encouragement to you, Mr. Mayor, in particular, the leadership team at the administration, that the MOA and the union team should be restarted. The negotiations therein under the meet and confer under the existing contract terms. I'm not trying to suggest any different guidelines or any modifications, but we have meet and confer clauses that I think are appropriate, and I really want to urge through the resolution and my statements right now is let's come back to the table. I think, secondly, again, revisiting 2010-86, I don't want to suggest at any time at this meeting that we provide alternative guidelines, but I think it is appropriate to clarify what's in there. And I don't want to hash every line item. You folks can read as well. But line 35 in particular talks about some of the ways that we come up with an indexed average. And if you can see the line throughs on this, that's because we debated the very night of the approval of this document what was going to be in there. And I was of the mind then, and I still am, that the total burden cost of an employee is what the measure of your spirited negotiations and your increases ought to be based on, is the total burden cost. But you can see in this document, for example, that the CPI over 5 years is now wages. And so you sort of leave off the benefits negotiation part of that. So I think that I want to be clear that we should all get very educated on this document, and the mayor as well. And so when you look at CPI calculations, how those relate into what offer is currently on the table or through arbitration or being discussed again. And I guess my final comment is that it's a policy statement. Not only did I use the word leadership at the beginning, but I think the public, the employees, and perhaps the administration look for a leadership opportunity, and without overstepping my bounds, as Mr. Flynn may think, that I think it's real important to have a simple majority ratification opportunity. A simple majority for me is a priority vote of 6. That's after the contract's negotiated. I don't like the court doing our business. I like it back down at the people's level, which is the elected level. And I think that we have a chance to mediate. I think we have a chance to show our responsibility to that, and I think it also is our obligation to the union workers that we have at the bargaining table as well, to show that we are active in the negotiations. So all that ramble is, I would love this body to approve a resolution that re-encourages the administration to pick up collective bargaining again. Let's not wait till the courts in November 10th. Thank you.
For the record, Ms. Drummond has joined us, and Mr. Honeman, you're next.
Thank you, Madam Chair. I agreed with Mr. Starr in a conversation to clarify, I guess, the ordinance or resolution that was set in 2010, and how we were to do that without having a serial meeting and having a meeting so that we could clarify that information I thought would be beneficial. I was still, even walking in tonight until I could see the actual hard copy, a little unclear on what is the real purpose of tonight's special meeting. And frankly, I understand the policy. I understand, Mr. Starr, you really don't like the fact that it's a supermajority of 8. That's part of the process that's built in the code. I understand that we really don't want we didn't want the arbitrator. I'm sure the administration didn't want the arbitrator to implement, essentially choose and pick amongst what was negotiated, fact-finded, mediated, and then that person or persons, in this case here, Judge Serdaley. So there's a lot of things that I'm a little confused with, but what is clear to me is that the process seemed to work. Now, we can all sit and figure out what happened as to why a settlement or a contract wasn't negotiated and brought before this body for an approval or a disapproval. But in fact, the process worked, and I'm a little concerned that we're stepping into an area where we're pushing to maybe regressively, like an unfair labor. It just feels really uncomfortable for me. The process was the process. It is the process. And that said, I will say that as with any litigation pending before the courts, there are usually 2 parties. And I've always encouraged the municipality to seek settlement opportunities and to discuss through its legal counsel prior to implementation of a court ruling. We already know what the arbitrator said, and it's anybody's guess as to what the ruling will be before this judge at the court. So where the opportunities take place, I would urge the municipality's legal department to be very proactive, seek some creative potential settlements. And I think I differ from you, Mr. Starr. Instead of saying, let's look at the 2010 resolution, that there are a couple of us on this body that weren't here, let's look at opportunities that if someone walking into the room and they know, and I say the other party knows they've got a benefit that's exceeding what the resolution says, I don't think that using this as a guideline is going to get us anywhere. If we're going to resolve an attempt to settle, I would think we would offer a longer-term contract, for example. I don't know what we would resolve, but I would think that we'd offer a longer-term contract of 4 years or 5 instead of 3, that we perhaps try to spread out the cost of 15% over 5 years so it's 3% a year rather than 5% a year for 3 years. So something that's a little more creative that's somewhat win-win. And that much I'm clear on. I don't know, other than clarifying what the AR 2010, and I appreciate that because it's been helpful for me and beneficial for me since you were on the body at the time and I was not. So with that, Madam Chair, I'm still a little confused, and I'll wait to hear more of the comments. Thank you.
Mr. Flynn.
Thank you, Madam Chair. If you don't mind, I'd like to ask a few questions of people in the room. May I start with Mr. Wheeler? Mr. Wheeler, we've had some discussion about whether an action like this is acceptable under the Fair Labor Standards Act and whether it would be an inappropriate action on our part. Could you give a little guidance on that, please?
Through the chair, Assemblymember Flynn, having compared this resolution to what the Assembly has done in the past, looking at our code and conferring with attorneys in the area, or in the subject matter area, I do not see anything in this resolution that presents me with concerns regarding your issue with respect to labor law.
Okay. And then I'm not sure who in the administration addressed this to. Nancy's gone. Who was on the bargaining team, and if we were going to keep bargaining, who would it be now?
We would, since the previous director has retired, Daniel Fegley is our new director, and we would name the individuals when appropriate who would be part of the bargaining team. But she certainly is, as now the new director of the office, would be key involved.
Danielle is. Okay.
Yeah.
Okay. And if I may, one more. If there's a representative from plumbers and pipe fitters, I guess we're asking the administration to approach you and meet and confer. Do you have any real interest? If you were willing to answer the question.
Would somebody from the Plumbers Union please come forward? I see their president or their attorney. One of you, please come forward.
I drew the short straw, Madam Chairman.
All right. Did you hear the question, sir?
No, I did not.
Mr. Dunnigan, good to see you again. The resolution in here, as it should, encourages the administration to pursue further discussions with the union under the meet and confer clause of the, I guess, now existing contract, the preceding contract. Do the plumbers and pipe fitters have any particular interest in coming back to the table at this point?
It would depend on what the administration had to offer. It's hard to say whether we would have any interest. I would say that the way the resolution is written, I would agree with the comments by Mr. Wheeler. They're not asking us to come back to negotiations. What they're asking us is under our existing and currently in effect contract is to meet and confer. And we have an obligation to meet and confer, and if the city gives us the notice, and we'll show up. But in terms of, let me give you the best example. Let's say that this had turned out the other way, that the Judge Sir Daly, after 19 months and all these procedures, had ruled for the city. And let's say you guys got a resolution from an elected body, which would be the executive board of the union, saying we'd like to reopen negotiations. Guys, we negotiated for 19 months. There are no unfair labor practices. It was a good, solid negotiation. We followed every procedure. We got a result. And if you don't like the result, you need to look at the result. Why did we get a market-based adjustment? We got it because we deserved it. We got it because the guys are underpaid. And that's all there is to it. But in terms of you want to go back and talk to us some more, sure. But why would we give that up when we have Judge Sir Daly, a respected neutral, who had all the facts, has made that decision. And by the way, I gave every one of you a little booklet, and in the back it has the comps. You can read them yourselves. We were $11, $14 behind our comparables. So, but too long an answer. We'll be glad to talk with you, but the administration needs to come with something to talk about. If all it is what will you give up, those are going to be difficult discussions. What do we have that we can give up?
Thank you very much, Madam Chair. I don't have any further questions for Mr. Dunnigan. I'll just make a brief comment if you don't mind.
You've got the floor, sir.
Just that I don't see any harm in the resolution. I'm not sure I see any benefit either. Thank you, Madam Chair.
And can I clarify what book you said you gave us, what little booklet?
I didn't bring my
okay.
copy.
That one. Thank you. I know now.
Yes, ma'am.
Mr. Trini.
It's in tab 4, the comps. Yes, ma'am.
Thank you.
Thank you, ma'am.
Thank you, Madam Chair. When he was talking, I was reading the Federal Register. Interesting. The EPA just announced that we're going to go off the IM program.
Bravo.
We have a 30-day comment period to the 7th of October for the public to comment. They'll make their final ruling, but they're recommending that Anchorage be taken off the IM program. So to everybody out there that wanted to see this happen, we actually got it done. Now, to move back to this, we took the same action on this in '95, and I appreciate Dennis's level sending us the assembly action. I've been on here way too long, but I saw that we did this in '95. And, you know, we got the administration to talk to the union back then. All we're asking them is to talk, and that's in line with line 19 in the judge's ruling. And this is not regressive bargaining because we don't get into that. We don't bargain. We simply ask the administration and the union to talk again, and that's what this does. I'll vote for this, Madam Chair.
Thank you.
Thank you,
Mr.
ma'am.
Honeman?
I just had one more question. Mr. Dunnigan, if I could, I don't know if you need to, probably, but Madam Chair. When under the contract it says request to meet and confer, both parties could request this, correct? Either side?
Yes, sir.
And when that happens, is that done? I know Mr. Starr was saying like to do the people's business in the light of day. Are those discussions done in a negotiating sense, more under an agreement that there's no conversation of what's taking place in a negotiation outside the room until it's either presented before its body, either side?
There are no ground rules for meet and confer. It's an informal process, but it's a serious process. You don't ask for that unless you have something you really want to talk about. I couldn't tell you, whether things would be public or not, and the contract doesn't say one way or the other. It just says if the notice is given, you meet. And we would do that.
And is this similar or akin to negotiating when you have the negotiation process?
It's nothing like negotiations. Negotiations is a specific legal process which is complete and it's over. We're not agreeing to renegotiate the contract. This is what I call the holding hands time. In negotiations, you don't have to agree, and we're in process of that process. In a meet and confer, if you don't agree, the process is over. So unless you walk out of the meeting holding hands, you don't have a deal. And neither side has any legal recourse as long as the meeting took place. The meeting has to take place, but beyond that, there's no requirements.
I guess from a point, maybe I'm not asking the question right, but perhaps in negotiations, my understanding is that this body's not a part of negotiations at any time. All we see is the contract at the end.
This body was very influential in negotiations, but I would think in a meet and confer, I would expect to see a representative from the mayor, his office, and whoever he sends, we would respect and we would talk to them.
But this is not like the cameras aren't invited in. This is not something where it plays out in the public, like a public negotiation you're not going to trump it out, the position of where you're at. And I guess my concern is that I'm hearing, at least I know I hear the administration almost daily trying to talk about how it was a good offer, it was a good deal, but really in the end, I haven't heard the plumbers and pipe fitters doing the same thing. I'm a little concerned if we're going to be in good faith negotiating a settlement before the courts, or in this particular case, we're going to be urging the administration to do this in good faith. Is this a process that needs to be something that's a little more, I should say, not necessarily confidential, but discussions being kept between the parties until, I mean, maybe it's two separate things I'm thinking of.
Well, let me say this. If you were to advise the administration that this was not to be a forum for sound bites for the press, and that you really want to get something done, we would honor that as well. I don't think you can give us that order, but I think, Greg Walker has said, fine, if you want this to be confidential so that they can report to you, of course, and we can report to our members, but no press releases and no press discussion. That's fine with us. You'd have to work that out on your side. Our side's good with that if that's what you want to do.
Okay, thank you.
There's no one else in queue. So at this time, I'm going to assume you're ready to vote. Oh, they're absent. Okay, I was thinking, who's absent? Okay. All right, that is approved, 9-1. There are no other.
Move to adjourn.
Thank you. That's what I was looking for. Thank you. We are adjourned.